Well, good afternoon and welcome to another edition of John's Rants. Today we're going to visit an old friend, independent contractor law. And the reason that we are is because it has come to the forefront again, particularly in the area of the relationships between brokers and the agents. Some of you may recall a year or two ago, we were thinking about a case called Barisani because a realtor agent was claiming that she was an employee, even though she had been treated as an independent contractor. But when she was terminated, she tried to be compensated as an employee. So the issue was resolved, the case was settled, and the issue went away. Recently, in a case called Dynamex, the California Supreme Court resurrected the issue again. So let me give you a little bit of background. This is going to be a little more lecture than usual, and so I've got a little bit of a more prepared statement because I want to make sure I cover things. First of all, what is an independent contractor? It's a person who provides services to another. Could be another person, another entity, for payment, and they are generally presumed to be an employee unless the employer can establish that they are an independent contractor. Historically, independent contractors have included, of course, things like plumbers and carpenters, those kinds of people. But with the law changing, while plumbers and contractors are probably still independent, the gig economy has kind of transformed to where a lot of people are now working for themselves as independent contractors, but the state wants to make sure that they're getting their money. So the relationship between an independent contractor and a principal differs significantly depending upon what the employee-employer relationship is. Now, California Association of Realtors has two really great forms, and I'm going to refer to these forms periodically. One is the independent contractor agreement with arbitration, which is the one we usually recommend to our broker clients. The other is an independent contractor agreement without arbitration. And that arbitration clause has been generally considered to have been upheld by the Supreme Court. But again, there's a lot of litigation on that topic as well. So basically what we're talking about here is that contract lays out that the relationship is one of an independent contractor, that the associate retains sole and absolute discretion in some of their work, but not in all aspects of their work that are under the control of the broker, that the agent is going to cover most of their own cost. Again, there's some back and forth on that. And then there's some other issues, including termination of the relationship. In addition to the CAR form, of course, many of the franchises have their own independent contractor agreement. Now, what happened in 2011 was that the court looked at the arbitration clause and said, yeah, it's probably going to be upheld, but I will tell you that the California State Legislature and the courts are still looking at many of those issues very, very carefully. Then in April of this year, April 30th, 2018 to be exact, the California Supreme Court, in a case called Dynamex Operations, unanimously announced that there's now going to be a brand new test for who is and who is not an independent contractor. Under an old case called Borrello and in some other cases and statutes, there was about a 16-point test. And that's what most of us used to analyze the differences between an independent contractor and an employee. But now there is a new ABC test, 3 simple questions. First, the Supreme Court said, everyone is presumed to be an employee. So whether you call someone, whether it's a transaction coordinator, whether it's an agent, whether you call them an independent contractor or not, the presumption is going to be that the person is actually an employee. Then you have to look at 3 different issues. 1, that the worker is free from the control and direction of the hiring entity in connection with the performance of the work that they're doing. Obviously, that isn't completely true with a broker and an agent, because the broker is responsible under California law for supervising those agents and is also liable for some of their negligent acts. The second part of the test is that the worker performs work that is outside the usual course and scope of the hiring entity's business. Again, when an agent does work for a brokerage, the brokerage is in the business of selling real estate. The agent is trying to sell real estate. Clearly, real estate agents don't meet that test. And then, of course, the worker is customarily engaged in an independently established trade, occupation, or business of a nature that relates to the work that they're performing. For example, I'm a lawyer. I am hired by Pacific West or by a broker client, but I have my own corporation and I am outside the association or the brokerage control. I have my own independently established business, so I meet the three-part test, and I practice law. So what is the Dynamex impact on real estate and real estate agents? Well, the good news is that even though real estate agents would not meet the three-pronged test, there is a statute. It is Business and Professions Code Section 10032, and it specifically states that real estate agents and brokers can elect to treat the relationship as an independent contractor if the relationship meets the test set out in the United States Tax Code. And that test says as follows. 1, that the individual is duly licensed. So if a person working for the broker is acting independently, such as a property manager or somebody like that, or a sales agent, but their license has lapsed or has been suspended or does not exist, then it does not meet that test. The only people that would meet this test would be properly licensed people under the Department of Real Estate's Business and Professions Code. Number 2, that substantially all of the remuneration, the income that is directly related to the sales or other output related to the sales. So therefore, most real estate agents who work on a percentage of the commissions that they earn for the brokerage would easily meet that test. And then lastly, that the services are performed pursuant to a written contract providing the individual will not be treated as an employee for state tax purposes, that the independent contractor status is recognized, but it does not remove the supervision that is regularly required. So let's look back. Number 1, you got to have a license. Number 2, you got to earn commission, not salary. So therefore, anyone who's on a salaried basis does not meet the test. And number 3, that you have a written agreement. Again, the franchise agreements would suffice, or the CAR forms that are available. And then, of course, lastly, that the broker continues to supervise that particular issue has not been removed. There's nothing in the case that would indicate that the provisions of 10,032 are being overturned. But again, now that the issue is at the forefront and in light of some other changes to what's going on up in Sacramento, this is now an issue that we will be keeping an eye on. It is pretty clear, however, that transaction coordinators, administrators, some employees of teams, for example, probably could not meet even the 10,032 test. Therefore, you look at the ABC test, and probably those people are going to be considered to be employees. There are some pretty severe consequences if you don't make sure you adhere to the rules. There's a lot of civil penalties. There's going to be liability for unpaid taxes, workers' compensation, for example. There could even be attorney's fees and penalties up to $100,000. So again, when we look at this issue, very complicated. Clearly, all brokers should make sure that all of their agents are properly licensed. Most of them are going to be paid commissions. And lastly, that the contracts are in writing and are current. If that's done, at least under current law, you will be considered to have your agents be marked as independent contractors. That could change down the line. We don't know. But for right now, it looks like agents are pretty safe so long as you meet those tests. Again, thank you for watching, I should say, today's rant. There'll be more information in the coming months. We're going to be talking very soon about a new code of ethics change that will change the way agents present offers and how it will be determined whether or not the listing agent actually presented that offer to the seller. So that information will be coming down the road because the code of ethics will be changing sometime on or about January 1st of 2019. Again, thank you, and you have a pleasant day.